don't have to do what you say, sir.
5. That's like saying you're talking from somebody else.
So here we are again.
Here we are.
We're
Right?
not able to get through your initial hearing.
I'm not here for a murder trial, sir. I'm here for a possession charge. And
I know why you're here.
Pushed on a March 20th case that I have.
All right, Mr.
Clymer put me.
I'm holding you in contempt.
Okay, that's fine, sir.
I'm
that's
sentencing
fine.
you.
That's fine. You're gonna see.
I'm sentencing you to 30 days in the Porter County Jail.
Fuck you, dude.
I'm sentencing you to 60 days in the Porter County Jail.
How about you send me to the old Porter County Jail that's right there? Because where I'm at is next to the LaPorte Airport, sir.
Mr. Broadway, would you like me to add another 30 days?
Why don't you add my name right, sir? My name is Jamie Clifford Broadway. Get that right. My name was changed when we came back from the war,
another 30
sir.
days. I've now sentenced you to 90 days in the Porter County Jail.
Whatever.
So simple. It is so simple. I'm not a flight risk. You all know where I live at. I'm sorry for raising my voice, but I'm always put as a different in this place.
I'm required to advise you of your various rights in this matter. You have the right to hire an attorney to represent you. You have the right to have an attorney appointed to represent you if you cannot afford an attorney. You have the right to a public and speedy trial by jury, and you have the right against self-incrimination.
I received nothing. Can I say something?
Go ahead.
This case that you're talking about is a summons for March 20th. We're not even talking about why I'm here when I got transferred. That's what I don't understand. That's why I fired off at you.
Yeah, I understand, Mr. Broadway. Like I explained the first time we met, the summons went out, but because you were already in jail, they wanted to make things convenient. So they just wanted me to do the initial hearing while you were already in custody, which was fine with me. So the February, what was it? 20th or whatever date the summons date was, that was vacated. March 20th. So you don't have to be here on March 20th. That date was vacated.
That means your speedy trial is something that I'm still talking about why I'm here. From Speedway and the possession charge was Clymer transferred me to you for that charge. And none of that is being discussed right now. I have 3 different cases going on. I got a Toadies case with false informing, and we got pulled. We didn't even get pulled over. We ran out of gas, and they said they were going to help us. And then now I came here, got re-OR'd, I'm supposed to say. So I just want to go home, sir. And we can do this.
Broadway. You keep doing a couple things which you need to stop doing. One is that you keep talking about your defenses out loud in front of the prosecutor. You should not do that. You should only talk to about your defenses in front of your attorney. If you're going to represent yourself, you need to do that in some proceeding other than in front of me, because I don't need to hear any defenses until your cases go to trial. You talked about the pending case you have in front of Judge Toady. I'm aware of that. You've got the pending matter in front of Judge Toady. That's why when I'm done with the hearings that I have to complete with you today, I'm going to transfer your case to Judge Toady because he's got cases. Also, Judge Clymer transferred your case to me. I should never have had that case. It should have gone to Judge Toady because he's got the pending case, the first pending case. Okay.
I understand that.
You were in jail already on F61636, which was the case that came to me from Judge Clymer, right?
No, I was not.
You were. They arrested you. You were in jail.
Sir, I got a summons by the officer. He told me that he was not going to press charges against me if I returned said package. I did that.
Okay. I'm talking about one case. You're talking about the other case.
Package. I'm in here for Speedways, taking food out of Speedway and having a box that was in my pocket that I found.
That may have been why you were arrested, Mr. Broadway, and I'm not going to disagree with you. That may have been why you were arrested on F61636. You were already in jail for that, and then they saw that you needed to have the initial in F6133, and to make matters easy, they brought you in front of me last Thursday so we could do the initial hearing on that.
But that's not stating why I'm here. This case, why I'm here, is not what you're talking about. But what I'm saying is the officer said he was not going to press charges if I gave him the said package. I gave it to him. The next day, and my door was even open, and it had a piece of plastic.
Broadway, I need to get through one more part, okay? You keep talking about your defenses. It does not help you.
I'm not. I just want to go home, sir. I keep getting set up to be here, and people get let out of here that has worse charges than me. And
Mr. Broadway.
Now the hearing takes a major turn. The discussion shifts from courtroom procedure to a habitual offender enhancement, which could add years to the defendant's sentence if proven.
Wait, I need to go through the habitual enhancement notice with you as well. You have been filed, the state has filed a habitual offender enhancement notice on February 24th, 2026. I would like to go through it with you. It says that on or about October 7th, 2024, here in Porter County, you were convicted of a felony in 64D02 2406 F6 6181, maintaining a common nuisance, which occurred on June 5th, 2024, and that based on that conviction, you were sentenced on October 7th, 2024 to 360 days in the Porter County Jail, which was suspended. Do you understand what they allege?
no, I don't. That's not my charges. That's not me. My name is Jamie Clifford Broadway. Not James Clifford Broadway. Jamie Clifford Broadway.
Okay, sir.
Explain
That's
that.
what the state alleges for the habitual offender enhancement notice. Do you understand what they allege?
I understand that. I hear that, but
Okay.
I don't agree with it.
I understand, and nobody's gonna, in a few minutes, I'll enter a not guilty plea for you on it, because you're innocent until proven guilty in this country. I need you to understand that the possible sentence related to the habitual offender enhancement is that you could have an extra 2 to 6 years if you're convicted of a level 6 felony, 2 to 6 years additional term, and it's a non-suspendable additional term. Okay? So if you're found to be a habitual offender, an additional fixed term between 2 to 6 years for level 6 felony can be imposed at the time of sentencing. Do you understand the possible penalty?
I do, and
Okay, that's all I need. And as required by statute, the court will enter a preliminary plea of not guilty for you on the habitual offender enhancement. Now, I'm transferring your case to
Okay.
DO6. Both of these cases get transferred to Judge Tody, and you have a hearing set with him on June the 15th at 8:30. So you'll be back in front of him on June the 15th at 8:30. And you should have copies of the order that I signed yesterday, or I'll sign today if I haven't signed it, that is the sentence for the contempt finding. I found you guilty of contempt last Friday, and I sentenced you to 6 months in the Porter County Jail. That's another reason why you'll be sitting in the Porter County Jail until the June
Well, then
15th.
I can't go pro se like I got escorted out of your room, because I mean, I don't want to look like this in the courtroom. I want to presume I got court.
You said you want to proceed
I
pro
got
se.
court clothes at home that I was ready for court.
The defendant insists on representing himself, but the law requires the judge to make sure he fully understands the risk before allowing that decision. That is why this moment is so important.
You said you want to proceed pro se.
You
wanna proceed pro se?
why you can't OR me and I be in court with my suit or tie.
And he will have to conduct a Feretta hearing related to the pro se. But in the meantime, I believe I have a duty to make sure you have an attorney within 20 days of being arrested.
I don't want an attorney,
And
sir.
I'm going to appoint the Porter County Public Defender Service
I
for
don't
you.
want that. I'm my own attorney. You know that, so does Judge Tody.
I don't
It's
think
so
you can get
simple.
a Feretta
It
hearing,
is so simple. I'm not a flight risk. You all know where I
By the end of this hearing, it is clear this case is not just about the original charges anymore. Courtroom conduct has become one of the biggest reasons the defendant's situation keeps getting worse. What would you have done in the judge's place?
live at. I'm sorry
you're
for
in jail
raising
now
my
because I
voice,
sent
but
you
I'm always put as a different in this place.
for your contempt last Friday. Transferring the
I don't
case.
call
We
that
have a
being
hearing on June the
You said
15th.
something about chickens, sir.
Judge Cody.
That is not
We're adjourned.
professional.
We're adjourned.
You gotta have to work me in, no, I'm not.
Please, please, Judge Fish, please. Please, Judge Fish, I have 3 kids that need me and I have to work to pay the bills. I only missed court because I was in custody. I never.
March 13th.
Yes, Judge.
Please, Mark.
Okay. We'll have you back on March 13th. We'll do it at 10.
I have court at March 13th. I have court on March 4th and March 13th. I can't keep.
I understand
case
that.
in my file shows the defendant failed to appear in November of 2024. Ultimately, he was released in December. No, I'm sorry. I'm going to go back further. Looks like his first failure to appear was in October of 2024. A warrant was issued. Then there was an attorney status on November 15th. Failed to appear for that as well. He was released. It looks like there was a notice of pretrial release violation filed in April of 2025. And then again, we're looking at the new petition and the addendum. And now there's been a warrant issued. And again, Judge, I'm going to ask that he be taken into custody. I think there are phones in jails, and no effort apparently has been made to contact his lawyer, the probation office, or the court.
And when I look back at this, I see what you're saying. Well, this case came back as a redocketed diversion, correct?
Yes.
Pretrial release back in September 2024. Failure to appear back in November 2024. Pretrial release violations in April 2025. And then the instant pretrial release violation. So yeah, I'll maintain our warrant. Take Mr. Garner into custody.
His emotional plea is powerful, but judges must follow the law, not just their emotions. Would you have made the same decision?
Excuse me, I was locked up, sir. Please don't do this. I have a family and I have bills to pay. Please.
Mr. Garner, I need to keep you in this jurisdiction until we can dispose of this case.
Excuse me, I have to go to court. Please, please, please. I have court next week, please.
All right, I
have to pay
made my
bills.
ruling. We'll take you into custody. And what's the best time for a court date, Mr. Worthley?
Please, please, Judge Fish, please. Please, Judge Fish, I have 3 kids that need me and I have to work to pay the bills. I only missed court because I was in custody. I never.
March 13th?
Yes, Judge.
Please, Mark.
Okay. We'll have you back on March 13th. We'll do it at 10.
I have court at March 13th. I have court on March 4th and March 13th. I can't keep missing court. They're going to keep issuing warrants, officer.
Oh, I understand, sir. I understand. That's your situation here.
Please don't do this. Please don't do this. Please.
We'll see you back on March the 13th, sir. 10
I
o'clock.
didn't do anything.
10 o'clock?
Yes.
Can I give her a
Pretty
kiss?
solid at 9.
Can I give her a kiss, Judge Fish?
No. You give her the keys. I thought you said a kiss.
No.
I apologize. Keys, yes. A
Fish,
kiss,
I was
no.
in custody every time. I'm not a bad person.
The judge believes keeping him in custody is the only way to finish this case. Do you agree, or should he have received one final chance?
Please, can you please?
No one is saying you're a bad person, Mr. Garner, but I need to keep you in this jurisdiction until we can resolve this case. We're adjourned.